The good thing about names on everybody, I don't know if everybody sees the names, so you get to know people.
Scott, you're set to go.
Good evening, everybody, and welcome to part 2 of the Connecticut Law Seminar. Tonight's guest speaker is attorney Win Smith, who I know professionally, personally. He's a great attorney, practices out of Milford, Connecticut, and he does real estate. He's a probate attorney. He can do all kinds of, he practices all kinds of stuff, and he can go into detail with you on that. Good evening, Attorney Smith, and it's all yours.
Good evening, Scott. Good evening, everybody. Yeah, so as Scott said, my name is attorney Win Smith. I practice law out of the law firm of Dye Smith Steele, LLC, out of Milford, Connecticut. My practice is a general practice, so I practice in the field of residential real estate law, commercial real estate law, business organizations, business representation, and probate, estate planning, contested probate litigation, and general business litigation as well. So that's what the vast majority of my practice is comprised of. It's a firm of 7 attorneys, 9 staff, so relatively small, but very busy. So that is a little intro on myself. Before we get into the seminar, if anybody has any questions as we go on here, feel free to, as Jim had mentioned, unmute yourselves and just say, hey, Win, I have a quick question for you. Because, we don't have to wait till the end. We have an hour and a half, so there may be some questions you have in the moment when I'm covering an issue that you may forget later on. So feel free to just jump right in and ask that question. So as far as the seminar tonight, as you could see there on the slide, the law is broken down into 3 categories: the statutes and standard of practice, which my understanding is you went over last night, and the regulations are actually quite fantastic. There's not a lot of legalese in them. They're pretty straightforward. It tells you what you should and should not do, what you're required to do or not required to do. And so it's an excellent tool and pretty easy to understand, which is great. And we'll talk about, clarity of the terms of the regulations. That's fantastic. And we're going to talk about clarity of the contract terms for your agreements as well. So it's the standard of practice, the inspection agreement, and then the claim or complaint. So tonight we will be focused on the inspection agreement, and then at the end we should have time and we'll go through complaints that are filed and how to respond to them and whatnot. So as far as the overview of the importance of the inspection agreement right there that you see in the slide. So the first most important point about the inspection agreement is, as you see it right there, establishing the clear expectations. That's, again, this is your opportunity to convey to the client the scope of the work that's going to be performed in the inspection, what areas are going to be inspected, limitation of the inspection so that the client knows exactly what will be done and that there's no confusion on the part of the client or anybody else. What you don't want is the client to later on come back and say, this is not my understanding of what you were going to do during the inspection. And then you get yourself into a situation where they could potentially file a complaint, or it's a situation where it will come up later, potentially in litigation or otherwise. So establishing the clear expectations going in the door is what you should strive for. Defining responsibilities in your contract. You are establishing your obligations as the inspector, as well as the client, such as the client providing information that you're going to need going in the door. So information about the property, what they should be telling you when you come there to begin your inspection, access to the property. If you don't have access to the property on that day, rescheduling for another day so you can get access to the property. So again, defining the responsibilities of not only you, the inspector, but also the client. So both of you will have the responsibilities, and those should be defined in your inspection agreement. As far as liability goes in inspection agreements, the clauses in the contract on limitations of liability, and I think Stan, we had briefly talked about this off seminar, but the clauses for this they're there to protect the inspectors for claims that are brought not only in small claims court, but in superior court. They can also protect you for claims that could potentially be litigated in some form of alternative dispute resolution, which we'll of course get to. An alternative dispute resolution would be mediation, arbitration, or something similar there too. So again, liability clauses should generally be in inspection agreements and can protect you later on down the road when you're dealing with litigation or complaints. Payment, you should certainly, obviously, as everyone knows, address payment in your contracts. Make sure that you're talking about in your inspection agreements, fees, payment schedule, what methods you accept for payment so that everyone is on the same page about the financials going in the door. Obviously, one of the most important aspects that you're going to concern yourselves with is how you get paid, but it also gives the client a clear expectation, going back to establishing clear expectations about how much it's going to cost and how they can facilitate payment for that. So I touched on alternative dispute resolution. So at this time, I think I'd like to talk about the different types of courts that you could potentially find yourself in. And this is generally, this is geared towards Connecticut law. So if anyone inspects properties in different states, this may vary, but generally it's generally the same. So most contracts should have clauses in there, if not all, for alternative dispute resolution. As I talked about, that's primarily arbitration and mediation. So arbitration can be binding arbitration. It can be non-binding arbitration, and it should probably be binding arbitration. And we'll go into a little bit more about arbitration because that's generally an item that is listed in almost everyone's inspection agreements. So there should be a clause in there for ADR. So putting a clause in there for alternative dispute resolution, again, as a practical matter, does not completely avoid having a case litigated in some type of court of competent jurisdiction. So just because you have a clause in there for mediation or a clause in there for arbitration does not mean that a party can file a claim in the small claims court or the superior court or some other court, right? It reduces the possibility that you will be in those courts, but it does not completely bar it. And I say that because you might say, well, I have a mandatory arbitration clause in my inspection agreement. How could they possibly bring this in superior court or small claims court if I have an arbitration clause in my contract? Well, that's because people can do all sorts of things. People can bring claims for items that aren't even applicable to your inspection agreement and allege those against you in the superior court. And I always say to my clients, bringing a claim and proving a claim are two very different things, and it can bring a claim for a whole host of different things. And you obviously have defenses to the items that are alleged against you in litigation. So let's take, for example, if you have a claim, well, we'll get more to this more when we talk about superior court, but if you have a claim brought against you in superior court, you can actually make a motion to the superior court to stay that matter, to pause that matter while you arbitrate the case, hopefully reach a resolution of the matter, come to an agreement, and then the superior court action, the legal action can be withdrawn. Okay? So, but again, we'll talk a little more about arbitration in just a minute. So, different courts. If it's not going to be arbitrated or mediated, what courts could you potentially find yourself in? And one of the courts that's a very popular avenue for litigants is the small claims court. And it's a popular avenue for litigants because the small claims court allows claims up to $5,000. And so if your claim is $5,000 or under, you can bring that claim in the small claims court. And in the small claims court, you don't need to retain an attorney for that. You can represent yourself in it. It's a very informal proceeding. There is no judge. There's no superior court judge. There is just a magistrate, and the magistrate will serve as the neutral fact finder, the neutral decision maker. And they will, of course, render their decision based on the merits after hearing the testimony from both parties, after hearing all of the evidence that is presented. And they'll, of course, issue their final decision. And a final decision in the small claims court is a final decision. It is non-appealable. So again, when you're talking about small claims court, a fabulous option for people, and they like that option because it's quicker, it's cheaper, you don't necessarily need an attorney, and it's a non-appealable judgment. So if you have a claim that's under $5,000, it may be a good avenue for you. Now, if your claim somehow rises over the $5,000 threshold, but you have already filed in the small claims court, then it would just be a motion to transfer the matter out of the small claims court and into a different court, likely the superior court. And it may not be you may have brought a claim that's under $5,000, but the person that you're claiming that against or is claiming against you, they may have filed a counterclaim, and that counterclaim may exceed the amount that is allowable under the small claims court, and then it may get removed either by motion of one of the parties, or it may get removed sua sponte by the court. So the court may make the motion themselves to remove it and put it in the superior court. So before I move on to the superior court, I did want to just touch on the probate court. And I know I was talking to Scott tonight, and I mentioned the probate court. Yeah.
Just before you jump on that, I just want to ask a question about arbitration. Can you pick? I mean, if you do arbitration, can you put in your contract some type of clause saying that the arbitrator will be somebody that's in the inspection or construction trade versus somebody that doesn't know anything about it? I mean,
yes, I'm going to talk about that. I'll get to that. The answer to your question is yes, and I'll talk about that further.
Thanks.
I just wanted to cover the different courts that you could be in. But yeah, so I will get to that, and that's an excellent question, and it will be covered. So like I said, I'm talking to Scott tonight, and I said, yeah, and that in litigation in the probate court too, and he said, well, probate court, that doesn't concern us. And generally, he would be right. But again, I do a lot of contested probate court litigation, and there are houses that get sold out of probate that many of you inspectors know, and I'm sure many of you have actually done inspections for houses that were sold out of probate. Now, probate operates very similarly to the superior court. Probate, you can litigate claims not on a cap of $5,000. You can litigate a claim that's $5,000 or $500,000. I've received decrees, final judgments for people in favor of my clients of over $1 million in the probate court. And the probate court is very different. Obviously, the small claims court was a magistrate. In the probate court, you have a probate judge, and they're an actual judge, and they are the neutral decision maker, the fact finder, and they may be hearing a case involving residential real estate or commercial real estate. And it may be that discovery is allowed, or evidence is allowed, or testimony is allowed of that residential property or that commercial property. And one of the attorneys may bring up the inspector or the inspection agreement submitted as evidence as an exhibit to whatever litigation is going on in the probate court. And that's allowable under probate rules. Those can be entered as evidence. And so the discovery process and procedure in the probate court operates very similarly to both the superior court and small claims court and whatnot too. So you may potentially find yourself in a matter where your inspection agreement could potentially be a central focus in some sort of litigation in the probate court. And in litigation in the probate court, is extremely common. I have found more and more that families get very angry at one another when it comes to residential properties and commercial properties, and litigation ensues very frequently. And so maybe none of you have been involved in the probate process with respect to inspections or inspection agreements, but there could be the potentiality that you would be there for that. So just know the probate court process operates very similarly to the superior court process. So what we talk about in just a minute for the superior court, just it's quite similar. Okay. So as far as and again, final decree from the probate court, unlike the small claims court, it is appealable. So if you get a final judgment in the probate court, that can be appealed, and it will be appealed to the superior court. That's the only place that it can go. So you may find yourself in a situation where there is a full case that was litigated in the probate court, and now you're in the superior court, and it's a brand new case again. It's called the trial de novo. It's brand new, and everything you did in the probate court really doesn't matter anymore, and you have to relitigate the whole case. It's a nightmare, but it can be appealed to the superior court. So superior court, the exact place where everyone does not want to be and everyone is afraid of usually. So the superior court can be a problem, and it is obviously not the top choice for anyone who has to be involved in litigation, because unlike small claims court, if you are an LLC, which we'll talk about, you should be, or if you're a corporation. So if you're incorporated in any fashion, LLC, corporation, or otherwise, you have to hire an attorney if you find yourself in the superior court. LLCs, as an individual, cannot represent themselves. They have to hire an attorney. The motion practice that occurs in the superior court is lengthy, is tedious, is expensive, and it's extremely time consuming, which again operates very differently from the small claims court. So if you're in the superior court, you are going to be looking at a very different cost, an elevated cost than you would if you were in the small claims court. The superior court, you're bound by rules of evidence, and you are subject to discovery, you're subject to depositions, you're subject to really a number of different items that probably will not occur in the small claims court. And you can open yourselves up to potential issues later on, especially if you don't have a bulletproof inspection agreement. In the superior court, though, again, as we talked about, if you have an arbitration clause, or even if you don't have an arbitration clause, a lot of times when cases are brought in the superior court, the judge suggests or the parties agree to submit themselves to either arbitration or submit themselves to mediation. And so it would be a motion to basically stay the proceeding until the arbitration is conducted or the mediation is conducted. And then if an agreement is not reached between the parties, then the case would continue. And I'll say as a practical matter, most of the time, if the court is going to suggest either arbitration or mediation, the case is likely going to settle. You will likely reach an agreement. It's very rare that the case would go all the way to the day of trial and have to be tried and have to have a decision by a judge or a jury. Those are very rare circumstances, and I'm sure anyone who has been involved in litigation who's on this seminar today can tell you that their case probably resolved long before there is any sort of trial. But again, sometimes not. Sometimes there's an impasse between the parties, and the case has to proceed to trial. And in such a case, they'll have a full trial on the merits. It could be a trial by jury or a trial by the judge, which is a bench trial. And after the final order, the final decision by the judge or the jury, that can also be appealed. So as we talked about, the probate court final decree, the final decision out of the probate court can be appealed to the superior court, or a final judgment from the superior court can then be appealed to the appellate court. So you may have found yourself all the way through litigation in the superior court, and now you find yourselves, okay, I won, but the other side just appealed into the appellate court. And you may say, my God, what do I do now? Well, the appellate court is even worse than the superior court, because the appellate court is even lengthier time periods between filings, even lengthier time periods between discovery motions and the discovery process there. There's lengthy briefs. There's more expense to filing fees, printing fees, attorney's fees. Maybe you have insurance, and we'll get to insurance, and maybe the insurance company is covering the litigation, hopefully. But maybe you've done something where the insurance company is not going to defend in the litigation. So if you ever find yourself in a situation where you have to litigate the case in the superior court and it gets appealed to the appellate court, you're looking at a whole nother expense as well that could be problematic. So,
Win, there's a question from Kyle. He's got his hand raised.
Yeah, hi. So a couple of things. So one, I'm DBA, right? So I'm a franchisee, and I got my own LLC, right? And you said that, in small claims court, I could represent myself, but going up to superior court, I need a lawyer. So I'm wondering if, as a franchisee, if, because I'm a franchisee, I'm not just my own LLC necessarily, if that changes things. And I'm trying to think of the other question I had. And let's say I don't have time for some reason to show up to court for whatever reason. Does that have much of an impact on how it turns out? Kind of like if you're filing a restraining order, someone files one against you, and one of you don't show up to court, that kind of, as far as I know, drastically affects the outcome of the case. So those were just some stuff that was going through my mind, but like the rest of this makes sense. I just wanted to kind of get some specifics on that if you have.
Yeah, absolutely. And I appreciate the question, Kyle. For the first part of your question, hopefully, and I don't know whether you did or not, but when you signed as the franchisee, many people who sign as franchisees to franchise agreements, and I'm sure you've seen your franchise agreement, and it is quite lengthy. It's voluminous. There's a lot of confusing terms in there and a ton of legalese. But hopefully you organize under an LLC or a corporation, and you sign as that LLC or that corporation when you sign your franchise agreement. Mm-hmm. Even so, I'm sure your franchisor had you sign as a personal guarantor on the franchisee agreement. And so you may have signed on personally, but you may be organized as a franchisee, at the onset. So if you are organized as an LLC or a corporation signing as a franchisee,
like DBA, like I got my LLC, like my inspection name LLC, and then DBA, the franchise. Yes. Is that what you're saying? Or
if you have an LLC, you're organized. Yeah. Your DBA is just, your DBA, the DBA just gets filed with the city clerk's office, and it's what you're going as. It's not your official business name as it's filed with the Secretary of State. When you filed your articles of organization for your LLC, you filed that with the Secretary of State. And when you filed for your DBA, at least you should have, when you filed to go by whatever it is you're doing business as, you filed that with your local city clerk or the city clerk of the municipalities that you're doing business in, to make sure that they know you're doing business as whatever the name is, right? But if you are an LLC, which it sounds like you are, you would have to be represented by an attorney if you have to go to superior court, even though you're a franchisee. Now, if you have insurance, I'm sure the insurance company will pick that up. But again, as franchisee, it complicates the matter, because I'm sure in your franchise agreement, there is a clause in there that any claims brought against you you have to notify your franchisor about. If there is not, wonderful, but I'm sure that there is, because that they could potentially be brought in as the bigger pocket to whatever litigation that you're going on. But again, they have all sorts of limitations on liability and limitations on damages and things like that. But if you're organized, you need an attorney in Superior Court. Okay.
Thank you.
Yep, you got it. So the appellate court, we talked mostly about that, and the difference between the decision maker in the appellate court is that, like we saw in the small claims court, magistrate, probate court, probate judge, superior court judge, and then the appellate court is a 3-judge panel. And so they will make the determination as to the case that gets presented to them. And the case that gets presented to them is whatever was determined in the superior court, and that gets raised up to the appellate court, and that's what they review. And I'm not going to touch on the Supreme Court, but just so you know, especially in Connecticut, the appellate court, you could win at the superior court, you could win at the appellate court, and then the opposing litigant could then appeal the appellate court decision to the Connecticut Supreme Court. And then if the Connecticut Supreme Court grants cert, they will then hear the case on the Supreme Court level. But I'm sure none of you have been in the Supreme Court with respect to your inspection agreement or inspections, and I'm sure none of you have even been in the appellate court. But if you have been to the appellate court for something with respect to your inspection agreement, I'm sure you've never gotten to the Supreme Court, and you probably never will in your entire career. Just know there's some nasty little pitfalls out there waiting for you on each level that you get to in the court system. So we will get to, okay, so let's talk about arbitration. And I know I stopped you, Scott, earlier on. But as far as contract requirements for arbitration, always have an arbitration clause in there. Include language in your arbitration clauses that arbitration will be against all parties involved, including individual inspectors, so that no one can try and get out of the arbitration. Everyone who is a party to the inspection and the inspection agreement is brought in so that you can have a full and final decision on the merits. Include the rules that you want in the arbitration. Many of them reference the American Arbitration Association or some other arbitration association. So just identify what rules may govern your arbitration. Identify the specific arbitrators. So you can have clauses in there that you want a skilled inspector to be your arbitrator. You could have multiple arbitrators. You can have a requirement that you have a skilled tradesperson, an inspector. You can have a tradesperson, inspector, and an attorney. You can choose in your rules on who you want the inspectors. You can choose those people and make sure that the people who are making determinations on this know exactly what they're doing, so that when you submit your case to them, they're not trying to learn on the fly. And you're not going to be able to say, oh, hey, I have 3 people and here's who we're going to use. Obviously, right? Both parties are going to want to come together, choose the arbitrators that are going to be involved, and then have them submit the case that they can make a full and final determination on the merits. And in choosing your language for the arbitration, choose a forum clause. And a forum clause is something like this is going to take place in the state of Connecticut and the county of New Haven. You can choose where that can be heard so that one of the parties can't remove it to, if you're in Greenwich, they can't remove it and place you in Danielson and make you travel 2.5 hours to get somewhere. So you can choose the location you want. All additional services that you provide in your agreements. So you have your standard inspection agreement. You have the regulations that give you requirements on what you have to actually inspect. And then, of course, you can add on to that. So you're not required to do certain things, but maybe you want to do those items for inspection. Or maybe your client is paying you to do additional services through the agreement. Make sure your additional services are also covered by arbitration. And it may seem obvious to you, but if you're filing or putting in an addendum to the inspection agreement, either include a clause that the rest of the agreement is incorporated in the addendum, or just put the arbitration clause right in the addendum to make sure that the new services that are being provided are also included for arbitration, so that you don't get into a situation where you do something and now you can't submit the arbitration and you find yourself in the superior court or small claims court or something else when you didn't want to find yourself there. So just make sure it's covered in all additional services. I think it's a good time to talk about insurance. So we have talked about a number of different procedures and mechanisms for people being able to file in small claims court, superior court, appellate court, and all that. And all of these sound very expensive. And yeah, they certainly can be. If you have insurance, you certainly limit the amount of out-of-pocket that you pay. So if there is any sort of litigation that's brought and you are insured, you have a very good shot at your insurance company covering you and representing you in that litigation if you are insured. So they will do that. It's good because you can have a say in who represents you in litigation. So you may want to put together a litigation plan with that person and talk with them about what the process is, what's going to happen, what discovery you should expect to be able to prep you on any sort of deposition that you may have to submit yourself to. And insurance will cover that and make sure that you don't have to come out of pocket for any litigation costs if they're going to pick it up. But some people may say, yeah, but the real question is, do I even need it? Because I'm sure the people that have it know, or the people who don't have it want to know, how much is it going to cost? And anyone who has insurance knows that commercial insurance premiums or any other insurance premium can be monstrously expensive. And if you use it, it's just going to go up. And if you use it multiple times, they probably will drop you. And if they drop you, then you have to get disaster insurance that's going to cost 3 times more than your original insurance. So insurance is frustrating, and it can be very costly as far as the premiums go. But as an attorney, I would have to recommend you get insurance because it does limit your financial exposure. Now, insurance is expensive and it does limit your financial exposure. But again, if you don't have insurance, right, someone may say, okay, I get that. I know insurance sounds expensive and you're recommending it, fine. But what if I don't have insurance? What are the real world ramifications for not having insurance for my company? And as we kind of talked about, any of these litigation costs or claims or anything else that would have been covered by your insurance carrier, that's now going to come out of pocket to you. So you're going to be coming out of pocket for whatever costs and expenses for litigation, for attorneys, for anything like that. But your financial exposure may only be limited to your LLC. So with your LLC, that's or your corporation. If you've incorporated, you're a corporation or an LLC or whatever the case may be, you have done that for a number of different reasons. One of the reasons is to provide yourself with the protections that these companies offer. A limited liability company is just that, right? It limits your liability. So your exposure would be limited to your company. And if you're treating your company like a real company, then whatever assets that are in that company, that's what your financial exposure is. They're not going to be able to come after you personally. They're not going to be able to come after your home or your personal finances or anything like that. Now, I say that there are some caveats to it, right? So you have provided yourself with the shroud of protection of your business because you have incorporated or you filed whatever with the Secretary of State to provide yourself with the corporation protection or LLC protection. But what some people do is, okay, well, I'm just going to open an LLC and then I'll never think about it again. And I have all the protections and I'm just limited to whatever's in my LLC. So if someone sues me, I'm okay. And I don't have to worry about anything again. And they're sadly mistaken, because if you are using your LLC or your corporation as a shell or a sham or something where you think you can get away with not following the rules and you subject yourself to claims or litigation where there is true financial exposure, your LLC, your corporation may not have any assets, but you're not using it as a real company. You're using it as a shell. So there's a doctrine called piercing the corporate veil or piercing the LLC veil, where they will be able to sue through your business and get to you personally, attach a final judgment to your home, or go after your bank accounts. So it's extremely important if you're going to incorporate or file for an LLC that you treat it as a real company, because it has real ramifications if you don't. And when I say treat it like a real company, open a business account. Do not commingle your business funds and your personal funds. Make sure you filed with the Secretary of State. If you have a DBA, make sure you have filed with your city clerk in your municipality. Make sure you do all the things that show indicia of an actual legitimate company. File your annual reports, pay your business tax, make sure you have an operating agreement. If you're multiple members in your business, make sure you have a multi-member operating agreement. Make sure you're doing annual meetings, keeping minutes, holding yourself out to the world as if you're a true company. And if anyone scrutinizes your company or your business records, you'll be able to provide them with everything that you've done since the inception of your business, so that if anyone were to say, well, they're not operating this as a real business, you can say, well, yes, we certainly are. And you'll be able to show that and prove that. Okay. So,
Win, just going back on the insurance.
Yeah.
What about self-insuring? All right. What I mean by that is just say, okay, it costs me $3,500, $2,500 a year. Taking that money and putting it aside and putting it in an account. And if something comes up, or say, hey, somebody says you missed my roof, and I say, okay, here's $6,000, $5,000. What's your thoughts on that?
I think it's probably a bad idea. And the reason I say that is because, all right, you may have that $5,000, $6,000 laying around, but if you don't have the insurance and take, for example, what you just said with the roof. If something happened to the roof and it causes substantial or significant damage or loss to the property, they may be going after you for a lot more than $6,000. They could be going after you for tens of thousands. So if you wanted to take the risk of setting aside the money you would have paid in insurance premiums to pay that out for a potential claim later on, I would say, why didn't you just get insurance in the first place? Because the problem is people probably aren't going to set that money aside. They're probably going to spend that money. And if they do, then they're probably not going to have enough for any claim that would have been made against your business. And if they did, it's going to be minimal. Maybe they have a slush fund of $5,000 or $6,000, but that may not cover a claim of $50,000. That maybe you accidentally missed something in your contract, and now you put yourself on the hook for whatever sort of liability that there is. So I would say if you have the money for it and you have the money to set it aside somewhere, you should just get the insurance outright.
What about somebody who has an LLC and they're being sued and they say, you know what, I'm closing my business down. I'm closing it down. I'm no longer, Joe's Inspection Company. I close it down. I say, I'm going to open up under another business. Can you still? How does that work? If say I'm being sued, can they go after the new company? Can they go after me personally?
Yeah, that becomes a problem of the claimant. That becomes a problem of the litigant, and it becomes a big problem because, just as you suggest, there are ways to going after you personally. If you were so easily just able to shut down and open up a new business, you're kind of showing indicia that you're using your company as a shell or a sham. And if you're able to do that so easily and open up elsewhere, then yeah, they're probably going to go after you personally, and you're going to have to then now defend that, and that's absolutely going to be in superior court. And so you're going to have to defend against that. And now you've just subjected all your assets, your house and other finances to that claim or a final judgment. So it could be it could be a remedy for somebody, but it certainly wouldn't be something that's suggested. I wouldn't say, well, if someone files a claim against you, just shut your company down and open a new one, because there are a whole host of issues with that. And like I said, it opens yourself up to piercing the veil of your company and them being able to attach your assets to the claim.
I see. I mean, I know there's builders out there that every house they build, they'll open up in a new LLC. The house is sold, then they close it and they open another LLC. Is that considered being a shell, or can you do that? Can you have multiple LLCs?
Oh, you can absolutely have multiple LLCs. And for example, when I have clients that have multiple real estate properties and their rentals, I suggest them opening separate LLCs for every single one, not having one master LLC for 10 different properties. So yeah, you absolutely can have separate companies or organizations for certain things. But again, the builders are probably opening legitimate companies and having bank accounts and putting the money through there and paying costs out of there and making disbursements through there. So could they potentially be using it as a shell? Possibly. Could they possibly be opening themselves up to liability later on down the road? Possibly. But I'm sure the people who are doing that are setting it up in such a way where it is, in fact, a legitimate company who's opening bank accounts and paying costs and paying taxes and things like that. So you can absolutely open a new one, run it as a real business, and shut it down later on, open up as a different company. That's no problem. But the difference in your first example is that somebody files a claim or gets a judgment against you, and you say, I'm shutting down and opening up shop somewhere else. So these guys, they may not have a claim against them at all, the ones that the builders that open an LLC for each new build, right? So I think they're two different scenarios. But yeah, you can absolutely have multiple LLCs. That's no problem.
Thank you.
Yep.
I have another question. Well, are retirement accounts accessible if your corporation is P and you're involved personally? Are retirement accounts?
Yeah, so that's a great question. Probably not. I mean, retirement accounts are they're a problem for a number of different areas of the law, especially when people estate plan for Title 19 planning. Title 19 is your retirement accounts are potentially subject to that. So just because you have a retirement account doesn't necessarily mean your retirement accounts are free of all claims and litigation and whatnot. So can they attach to that? It would be very difficult for them to do that. But if it's a personal asset of yours, yeah, it can certainly be brought into the litigation and be claimed by the litigant for them to go after as a potential avenue to offset on whatever judgment that they have against you. So
why would they not be an asset if it's a retirement account? But why wouldn't they be an asset?
Oh, I'm saying it potentially could. Yeah.
Okay.
It's definitely a personal view, but as far as being able to attach a retirement account for a claim against something that went awry from an inspection agreement or a property, usually those are limited to your personal accounts or the hard assets that you have. But yeah, your retirement account can certainly be subject to a claim in court. And if they know about it or they find out about it, I'm sure they will submit that as an asset for them to attach to.
Okay, thanks.
When in the contracts, when you have a limitation of liability, say 2-3 times the inspection cost, is that just ridiculous to have into the inspection agreement?
No, I would say you should certainly have limitations in there. As far as you, as a practical matter, being able to have those play out in real life and say, well, now I've limited this to 3 times the amount, and therefore, I'm free and clear from whatever claim or whatever judgment for litigation. As a practical matter, you're not. But it does sometimes prevent people from possibly bringing a claim against you because they see that you've limited your liability to that. And
Okay.
they may see that and say, all right, well, I can't even go after him for that, and it's not even that big of a deal, so I'm just going to move on and go on my way and worry about something else. So it can act as a deterrent, but as a practical matter, it's not going to be a full barrier to a claim.
Thank you.
Yeah. All right, so let's go to confidentiality, privacy, and non-disclosure. I think that's on, I want to say, slide 7 or 8, Jim.
Limitations of liability. Oh,
Yeah,
confidentiality, non-disclosure.
Yeah.
6.
So.
Yep.
So for these items, ensure that there are confidentiality and privacy clauses in your contracts, in your inspection agreements. This is good to establish guidelines for maintaining the client's data, making sure their data is being handled properly. And if you're maintaining your clients get very particular about how their personal information is used, right? So you ensuring to have these clauses like confidentiality or privacy in your contracts is just really going to build trust between you and your client. It establishes provisions in the contract that indicates that you as the inspector will take steps to maintain the confidentiality of the inspection findings and the client's personal information. So not only their personal information, but the findings that are found within the actual inspection itself. Regarding local rules, laws, or ordinances, the content of the inspection agreements really does vary based on local laws, regulations, and industry standards. So if you are practicing in a jurisdiction, just make sure that jurisdiction you're in, you're keeping up to date on the local laws or the local regulations or the local industry standards, so you can keep yourself apprised of that. And all of you went over the regulations last night, so you're very aware of what they say and what they require. But when you're trying to make sure and ensure that you have complied with local rules, laws, or ordinances, always consult with a legal professional on it. It just makes sure that if you have any specific questions as to compliance issues, are you being compliant with local rules or ordinances, your legal counsel will be able to say or give you a recommendation as to what to do differently if they think that you're not following them. On slide 8, talks about licensing and certification. And depending on where you are, you're typically required to obtain a license. And as you all know, in Connecticut, you are. But again, if you're practicing in an area, just make sure that you are required to get one. And even if you were potentially in an area that does not require you to have that. Their clients are looking for that. So they're always going to make sure that they are looking for someone who is licensed, usually licensed and insured, but certainly licensed, making sure that, there are a lot of different standards that all of you have to comply with, right? And they want licensed people doing that. You have to do continuing education seminars like the one we're doing now, like the one you did yesterday. So you guys are you're the go-to people on this, and that's why you're licensed, and that's why people want to hire licensed inspectors. Slide 9 talks about the inspection report. And again, as everyone's aware, after the home inspection is done, you're going to provide the detailed report to your clients. You're giving them a comprehensive summary of the findings that you have observed at the property, and also any potential issues that that you see there as well. You're highlighting major concerns. You're providing recommendations for remedial measures or for potential further evaluation if needed. And you're making sure that you're clear that you're not sharing that information with any third parties. And again, this goes back to privacy, confidentiality, non-disclosure. Make sure that if you are going to share the inspection report with anyone, you have your client's written authorization to share that information. If you do not have their written authorization to share that information, do not share it, because now you're just opening yourself up to a whole host of issues later on.
That's
and
funny.
again, I say,
because
yes,
I just turn to the seller or the buyer and I say, the agent will say, send me the report, and I'll say, well, it's really up to them, and then I just send it in there. So you're saying that we should get it written from them.
You should get
Definitely.
Yeah, you should get written authorization.
Okay.
Because verbal is no good, because if it becomes an issue later on, people seem to forget things very quickly.
If you have a clause in your contract, you give me permission to, send this to the real estate agent. Would that be sufficient when they signed it?
If you do have that in there, just draw that out and make them aware.
Okay.
Yeah, exactly. So they know of it, because again, we'll talk about the length and description of the inspection agreements, but they can be very lengthy and voluminous and have some legalese in them. So a lot of times, we all do it, right? We all do it. We don't read them thoroughly or read things that we're signing thoroughly. So they may just sign it and not know. So if you're going to have it in there, call it out to them so that they absolutely know what it is they're signing, because you don't want to get yourself into a situation where you shared it and they say, oh my God, what did you just do? And you say, no, you agreed to that already. And they say, well, I had no idea. That was just buried in the inspection agreement. You didn't tell me about it. So if you're going to have it in there, sure, but you tell them about it.
Would it make sense to have them initial the line item?
You could do that too.
Yeah,
You can certainly do that too.
I have it in my contract, and I have them print who they want me to send it to besides themselves, and then
That's
I have
excellent.
them initial it. That's one of the line
excellent.
items.
The only to my point to Jeremy was call it out to them anyway. And the reason I say that, you may say, well, I've written that they write the people in there and they initial it. Now we're in a digital age where the DocuSign has become a very effective tool of signing agreements. And when you DocuSign something, it's very difficult to have the whole page laid out and really go through it. People tend to just initial, sign, and then they're done with it. Yeah. So if you're having them wet sign it, okay, well then that's a different story. But if they're going to be docu-signing something, just call it out to them, make sure that they know.
Right. Attorney Smith, concerning the pre-inspection agreement, we were always, well, at least I was always educated that the earlier you can send it electronically, it gives you, if there is a problem, they say, well, I didn't read it. You could go in and say, I sent it to you a week before the inspection. I didn't show up with it at the inspection. You had plenty of time to read it. Is there a time of essence sort of thing on that?
Again, it's not going to prevent them from claiming that, but as a general best practice, you should absolutely send them that agreement well before the inspection. Give them an opportunity to review it. Give them an opportunity to ask questions about it. Come back to you. Both of you can go over it so that to your point is you're not springing it on them.
Right.
Because you got to manage their expectations with what they receive on it. Right. The contracts can be long and sometimes confusing to people because many of the clients that you get are not going to be versed at all, or if they're versed a little bit, well versed in the real estate sector or have a legal background. So to spring a pre-inspection agreement on them at the time of the inspection leads to issues later on, right? So yeah, certainly send it to them beforehand. Call important things out into the contract, like I talked about with Jeremy, and make sure that if they do have any questions, comments, or concerns, you can address that with them together. Not only that builds trust, but it provides you the ability to work out any issues before they arise.
Right. Thank you.
Yep. Okay, so this kind of leads us right into slide 10, which is contract clarity, right? The clearer, the better. Make it clear, make it coherent, make it concise. By doing all these things, you are conveying the essential details of the inspection report, and you are leaving no room for miscommunication, right? Making the contract expressly clear and concise minimizes your risk of legal issues arising later on, given that if there are legal issues that arise later on, the inspection agreement is probably going to be the central focus of whatever litigation is stemming from the inspection, right? So your contract is going to be entered as an exhibit, is going to be scrutinized by a magistrate or a judge or other attorneys or other parties or other inspectors or arbitrators. So it could be that your contract is the central focus. So you want to, again, you're making it expressly clear and concise. Contract clarity is key. As far as informed consent, the contract should state clearly what will be inspected and what will not be inspected. The contract should state any disclaimers or exclusions to the inspection. By doing all these sorts of things, you're giving the client the ability to make informed decisions, but also seek any clarification that they may have with respect to what is being inspected or what's not being inspected. Why is it not being inspected? Things of that nature. So again, it's just working with the client, making sure they are comfortable with it, and making sure that you are minimizing the risks of problems, complaints, litigation later on. Contract clarity also shows your professionalism and transparency of not only you, the inspector, but you're trying to complete the inspection, but you're also trying to build trust with your client. So by doing these things, you're building a lot of trust with them, and they're getting more comfortable with you, and that leads to repeat business or referrals later on. Contract clarity also educates the client on the property. It helps them make good decisions with respect to the property as to what they want to do moving forward after the inspection is done. So not only is it minimizing your liability, but it's also educating your client. And so we talked about managing the client's expectation, and that's what we just talked about with Jim, which is always just send it to them before, making sure that they have time to review it because it can be lengthy and sometimes confusing, especially if they're not from the industry. So now you've given them the opportunity to come back to you and work through the agreement if necessary.
How about your name in the contract? What should be in the contract as far as your company? It should be your company name. Should you refer to yourself as company? What do you think is the right thing to put in that contract?
If you're organized, the company.
The LLC. So it should be your company's name, LLC. if you're, I'm trying to remember what's, I had it changed because I had worded it differently. I can't
When
remember.
when you're signing it, if you're a single member LLC, at the end of it, you're going to be signing it your name, duly authorized representative or authorized representative, or so your name is likely going to appear on there somewhere. But as far as who the contract is between, you're going to be using your entity.
Are we managing members if we're solo, or are we members of the LLC?
It depends what you filed on your articles of incorporation with the Secretary of State, but you should be managing members. Sometimes people just put down members when they file with the Secretary of State. You can put managing member, you can put member. So I would just, again, this is all public information. So you can look up your company on the Secretary of State's website, and whatever is listed there, you should be consistent in how you use, your name or your company's name out there in the field.
And then the other thing that we've been educated on is if you're, Smith's Home Inspection LLC, your letterhead should have LLC. Your advertisement should have LLC. Everything should match.
Yes. Yep. Everything should absolutely match. And it seems obvious, right? But people don't like to use the ending. They're ABC LLC, and they like to use ABC because they have a great logo and they have all that. Be consistent with how you're holding yourself out to the world, right? Use the LLC, use the Inc., use the incorporated. If you have a DBA, you'd be using the full term.
If you don't, are you opening yourself up for litigation? If you don't do it, are you opening yourself up for litigation? Can they break that corporate veil?
It could be a factor that goes into the consideration, but it's not determinative. So what I mean by that is if you were to, you're pretty consistent in how you use your company, ABC LLC here, ABC LLC there, and then on your car wrap, you used ABC. Well, that's not gonna allow them to pierce through the corporate veil just because you missed it on something, right? If you're pretty consistent about it, be sure you are consistent about it. But if you don't use it here and there, it's not going to be absolutely determinative that they get to pierce through your company protections and go after you personally. I wouldn't worry about that as long as you're pretty good about how you hold yourself out.
I have one quick question. Do we also need to include our license underneath our corporate names? Because I know in my home inspection business, I do.
As far as a standard term in the contract?
Well, on any of my advertising in my home inspection and my home improvement, I was told that I need to incorporate my license number in any of my advertisements, my wraps, and my letterhead. Does that hold true with home inspection?
It's a good practice. It's probably a best practice. Is it an absolute requirement that would subject you to, having the veil of your LLC pierced or opening you to litigation outright? Probably not. But as a best practice, absolutely.
Okay.
I think that's a state thing too, Brian. From what I remember hearing the same thing, like all, stuff on your car should have your, registration, license, and all that. But most guys no good.
Yeah, and I was about to say, as we know, as a practical matter, that doesn't happen.
No.
So I don't know if I've ever seen a car wrap with a license number on it. maybe there are, but it's very
well.
rare.
Electricians and plumbers always have one.
Plumber, yeah.
Master plumbers or whatever.
I meant for inspectors, but yes, yeah.
No, I haven't seen an HOI yet. Or agent.
So if we can go to slide 12, Jim. Yeah. So essential elements of the inspection agreement. So this is in your contract. This is what I call the who, what, how, and where of your contract. You're identifying everyone who is involved. Identify the parties to the contract. You see it right there: home inspector and client. Outline the scope of the work. We talked about this already previously. Again, what is going to be inspected, what is not going to be inspected, what any exclusions are. Are there any additional items that are going to be covered through the inspection that you negotiated with the client and that they're going to pay you to do in excess of what you're required to do? Is there an addendum to the contract? Make sure that's included as well. The fees, right? How to pay, payment structure, different forms of payment that they can make. Where, right? This seems obvious, but the exact address. Do you have access? How you get access? Permission to go to the property. Do you have a process of rescheduling that inspection? Some people don't think about that, but if you do, perfect. If you don't, think about what happens. You know, life, there's a lot of things happen in life, and people have to reschedule the inspection that they previously got you on the property for. So what's your process for that? Just make sure it is clear to the client on these items, right? We talked about contract clarity before, and being clear on who's involved and what's involved and how they can pay and where the inspection is happening and how they can reschedule if necessary, which helps the client be more comfortable with you and be more comfortable with the inspection itself.
Hey, Wynn, I do an inspection. Lisa hires me for the inspection. Lisa's parents show up. Dad says, I want to pay. And I take a check from him or a credit card from him. They didn't really complete the contract, did they?
They did
Lisa
not.
and her husband.
No, they did not. So what the best practice that you want to do here is always make sure to get payment with the person who contracted with you. Right.
But if we can't, and I also know inspectors, maybe not a lot, maybe one or two, that will say the price of the inspection is $500. The end of the inspection, you know what? This was a lot easier for me. I'm going to knock $25 off. You're a veteran. You're AAA. And they pay $475. They don't write it as a discount on their inspection, on the invoice. So they didn't fulfill the contract because they didn't pay the full amount.
What are they looking to do afterwards, though? I mean, if you're going to change the terms or change the parties involved to the contract, the best thing you can do is add an addendum to the contract or a contract modification to include whoever is going to be a party to the contract or who's paying on the contract, or if you change the amount of the contract. As a practical matter, a little difficult, right? You're talking about knocking something off at the property. Now you're talking about doing modifications and addendums. So as a practical matter, that gets a little messy, but yeah, everyone who is paying, or if you are changing the terms, you should probably have an addendum for that.
Okay, thank you.
Yep.
Can you have a statement in your payment terms, Attorney Smith? Can you have a statement in your payment terms that should someone else pay, that the client remains the client?
I guess you could. The problem is you're inviting a third party who is not in privity of contract with you.
Right.
And that opens you up to a number of issues later on. So they're not bound to the contract, and the person who signed it is, even though they may not be paying. So you just want to make sure you include whoever that is into the contract through an addendum. So they may still remain the client, but whoever it is that just paid doesn't have any privity of contract with you.
Okay, the above named contract agrees. Well, my statement says that the client remains the sole client in the agreement and agrees to comply with all of its terms. So in other words, the above, if it's paid by someone else, the above named client agrees that should the fee be paid by others, the above named client remains the sole client in this agreement and agrees to comply with all of its terms.
Yeah, you just want to know if they can. You just want to know if they can get out of the contract, even if it was paid by someone else. And they still have their responsibilities in the contract that they sign. So they're not going to be able to remove themselves as the client. So yes, they'll still, that's fine.
Right.
They'll still remain as the client. They're not going to be able to, cancel the contract because of it.
Right.
They still signed it, and they're still moving forward with everything else.
Right. All right. Thanks.
Okay.
Quick question.
Yeah.
Sorry. What happens if we have a client who creates their own LLC because they don't want their name out there to do the inspection, and we put the agreement into the LLC's name? How does that protect us?
Well, it doesn't. And so if you do have the LLC, if the client is an LLC, you want to make sure that not only are they signing as the LLC, but they're guaranteeing it personally. So
Right.
the member or members of that LLC.
Well, many times it's the attorneys that are setting this up for us because they don't want us to know who the actual client is of the house that they're purchasing.
Yeah.
And so they'll set it up in an LLC, and we'll send out our agreement in the name of the LLC.
Yeah. If they refuse to sign it in any other fashion, it is fine to have an LLC be the signatory and be the client. Just know that if they try and, let's say they stiff you on the payment or something happens later on, you may be going after an entity, kind of like what we talked about before, that doesn't have any money. That's not going to be able to pay you. So if you haven't had someone that personally guarantees it, then you're kind of out of luck.
Well, usually the payments are up front, and normally the payment is there because it is somebody who doesn't want to be known.
Right. And the problem could be that you're doing additional work at the time of inspection, and you've agreed to do that with that LLC that you might not get paid later on. If you've already been paid, okay, then no harm, no foul. That's probably okay.
Well, payment is due at the time of the inspection. So
yeah, best practice, get the personal guarantee.
Yep. Thank you.
So slide 13, pitfalls and mistakes to avoid. This touches on much of what we have talked about previously, right? So we talked about don't use any ambiguous or vague language, clear and concise. Contract clarity is key. Don't be vague as to what exactly is being inspected at the specific property. Do not fail to call out limitations or exclusions of work. Make sure to go over that with the client, making sure they're aware of any limitations in your agreement or any exclusions that there may be. Address the schedule and timing of the inspection. Don't fail to not mention that. Failing to outline the format, content, and delivery method of the report itself. Failing to do that can cause confusion, aggravation. Open yourself up to a complaint later on. Fail to do that. Failure to address dispute resolution or alternative dispute resolution, like we talked about much earlier, and that helps to resolve issues later on. So make sure that's addressed in the contract. And then, of course, failing to stay up to date with regulatory rules or compliance requirements and things like that. The client concerns, we kind of talked about this before, and this is the timing of when you send them the agreement, going over the agreement with them. Just make sure to send it to them before the agreement and give them the opportunity to come back to you with questions so that they are clear going in the door. I mean, you should be clear about your agreements as well, right? So, but you want them to be clear so that they can trust you and prevents them from filing complaints later on and things of that nature. So, best practices. So for your inspection agreement, you're going to want to make sure, again, no one wants to find themselves in a situation where they're dealing with a complaint or they're dealing with a claim in the small claims court or superior court or any other court for that matter. So keeping comprehensive and continuing records of the executed agreement in all communications with the client is key. And as I said before, we talked about authorization in writing. Make sure everything's in writing. You know, as a practical matter, you talk to the client on the phone, you talk to the client at the property. Those things can't be avoided entirely, but keeping a record of all communications with the client, at a minimum, to the most important aspects to your inspection agreement and terms and negotiations, that's key. Because, like I said, people forget things very, very quickly. You would be surprised what they seem to recall when it comes time for litigation or filing a complaint. So, keeping records is key. Staying in communication with the clients throughout the whole inspection process, so you can answer any questions they have, any concerns that they have along the way. Make sure to document, as we talked about earlier, any addendums or modifications to the agreement. They have to be well documented and in writing, never oral, signed by all the parties who were parties to the original agreement, and include those in your records as well. And then, of course, your best practice is to stay educated, much like the seminar you did yesterday, the seminar you're doing today. And everyone is really, many professions are required to do that. Attorneys are required to take continuing legal education courses in their practice. So staying educated, looking at the regulations consistently is just going to keep you, is going to make you a better inspector and keep you far more informed than your competition.
Attorney Smith.
Yeah.
If I send two things. First, if I send an agreement electronically and they don't sign it and I do the inspection, is it true that that's considered a verbal agreement then? And there's a 2-year liability? And if they do sign it, there's a 6-year liability?
Well, for the first example, they didn't sign it, but did they agree to have you do the work?
Yes.
They did.
I showed up, I did the inspection.
Right. So as long as they said yes to you coming and doing it, right? Presumably they did, right? You wouldn't be there if they didn't, if they said no.
Right.
But as long as, if you sent it to them and they said, yeah, Jim, you're good to go. I need you to be here on X day. You're going to do that. And for whatever reason, you don't have the signed contract. Yeah, oral contracts are enforceable. They are. They're not recommended at all, but yeah, they're certainly enforceable, and they are limited by the time frame that you talked about. And then the written contracts, obviously best practice. Those are recommended, and yes to the timeline too. So they are enforceable, but again, there's just so much room for inconsistencies, complaints, litigation for oral contracts, because then it's really just he said, she said, and it's a mess.
Secondly, I'll ask the members, if you're not talking, mute yourself. Thanks. All right, go ahead. Sorry.
Yep. So I think we can go to the real life examples you have on slide 15 to 18.
Yep. I'm going to keep going.
You want to give that code out?
I'm going to keep it here for just a couple more seconds, and I think we're good. Okay.
All right. So, I'm not going to read through these, but again, these are examples of terms in the pre-inspection agreement, and a lot of it is kind of what we talked about. I mean, we talked about all these items, right? And the first is talking about what is going to be included in the written report, and it lists out all of those items. It's talking about the scope, right? We say explain the scope and be clear about it. It talks right in there about the scope of the inspection and readily accessible areas of the building, limitations. We have in here exclusions. So what's going to be excluded from your inspection, which again, we talked about how important that is. And then of course, limitations on liability for your company, your employees or agents, and things like that. On the next slide, there is a limitation of liability clause, which I don't love. And And the last sentence of that says that it allows, well, I'll read it to you. If you'd like unlimited liability, there'd be an extra fee of $3,500 to allow us to hire appropriate professionals. I would not recommend allowing the client to purchase unlimited liability for an inspection. But again, as a practical matter, who am I to tell you not to take $3,500 if they're going to, if you have someone ready, willing, and able to do those things. But it just allowing someone to have unlimited liability can open up a whole host of issues that you really don't want. So I would keep it as a limitation of liability and don't allow them to do that. But again, who am I to say don't take $3,500? So I know someone had asked me previously about, and again, arbitration, we've talked ad nauseum about arbitration, but arbitration clause right in there, going over rules of the arbitration, what it's governed by, if there's disputed payment, what happens then, things like that. So talk about your arbitration, talk about the rules of arbitration, talk about your arbitrators, and have that alternative dispute resolution clause in your contract so that you can avoid costly litigation. So what I was going to say was, I know someone had asked me previously about severability, which you see in the contract right there. And as it says, this says that the parties agree that should any provision of the contract be held either invalid or unenforceable, the remaining provisions of the contract shall remain in full force and effect. What does that mean, right? Well, let's take, for example, the paragraph directly above it, arbitration, right? Let's say you horrifically drafted that arbitration clause and it is not applicable to Connecticut and would never be applicable to Connecticut, and it's just not going to be allowed. If you did not have a severability clause in your contract, it could be argued that because your arbitration clause is invalid and unenforceable, the whole contract is invalid and unenforceable. So what the severability clause does is it says if any of the clauses are invalid, only that clause will be removed. And the rest of the contract is still valid and enforceable. Does that make sense?
Yeah.
Okay.
Can you make people, can you make people pay your attorney fees? Can you have a clause in there if there's any attorney fees, or fees that you incur during their suit against you, or if you
Absolutely. Absolutely, and you should. Absolutely, and you should. That was going to be one of the last items, and that is you should certainly have a clause for attorney's fees in there. If you have to bring litigation to enforce the agreement, attorney's fees clauses attorney's fees in Connecticut are only allowed by contract or by statute. And if they're not allowed by your specific statutory provisions in the regulations, can't get them unless you have a contract. But if you don't have a contract, you can't get your attorney's fees. So yeah, certainly put the attorney's fees provision in there so that if you do incur substantial attorney's fees and you don't have insurance, you can get those from the other side.
The word "shall be" is very important in the contract, from my understanding, because you could say it. Go ahead. Under arbitration,
yeah,
it says it is agreed that any dispute shall be resolved. I know that I've seen some contracts where it says any dispute may be resolved, could be resolved. Shall be is sort of, this is the way it's gonna be. I know it's not 100%. They can take you to different courts, but does that help?
It would certainly help, even if they were take you to superior court. This would allow you to have the motion to stay the superior court action, to submit the parties to arbitration, and let the judge know. And again, judges love not having to do work. They love not having to make decisions and determine the final merits of a case. So if they can just dish this off to someone else, or an arbitrator, they would love to do that. So yeah, you would present this and you would say, Your Honor, we have an arbitration clause in the contract, and I'm filing a motion to stay the proceedings so that we can submit the parties to arbitration. And it's likely that you would come to an agreement in arbitration. So yeah, shall is important because if it does not say shall, then if you do file a motion to stay, the other side could certainly say, well, no, we never agreed to do this outright, and we want to do it here. And so we should be allowed to do that.
Went on to the next slide, disclosure statements.
Yep. So earlier we talked about the disclosures of any information that the customer or that the client may have for the inspector. Again, when you're going over these contracts, they should know of their responsibilities in the contract. We talked about responsibilities of the inspector and responsibility of the client. So you should know of things like this going into the property, because if it becomes an issue later on, someone's going to point to you and say, why didn't you find this? Why didn't you see this? Why didn't you know about this? And you would say, well, if it isn't observable, if the place wasn't readily accessible, no one told me about it. And if they didn't tell me about it, how am I supposed to know? So the information that you get from the client is obviously particularly important here. And again, many of you, I'm sure, encourage the client to come to the inspection. Inspections, as you know, take quite a bit of time, so they may not want to do that, but it would certainly help them as a comfortability factor in seeing these items and in going through them with you, because as a practical matter, clients, first-time home buyers in particular, they end up freaking out when they see an inspection agreement. And I have seen many deals fall through at the inspection when they receive their inspection report, because the inspection report lists a whole number of different things, and the person says, oh my God, there's so many issues with the property. Well, there actually may not be that many issues to the property. You may just be pointing things out that you have observed. It doesn't necessarily make it bad. So having them there, you'll be able to talk with them about what it is that you're observing or what you're going to put in your report, as opposed to giving them a voluminous document with all these different items in there, and their head is spinning and they don't know what to make of all. So it would be good to, have them there for it. I see we only have a few questions left, and I don't want to, or a few minutes left, and I don't want to prevent people from asking questions. So before we end it, does anyone have any questions with respect to the items we went over? I know we didn't get to complaints, but any of the items we went over, contract terms, or anything like that? Okay, good. So I told Jim and everyone else that if anyone does have any questions with respect to drafting of your agreement or the regulations or best practice you should do going into having a client sign an inspection agreement and actually doing the inspection, feel free to reach out to me as a resource. Email me. I have countless realtors reaching out to me all the time to ask me a quick question about what they should do in their agreements, and I'd like to provide the same opportunity to all of you to do that with me. So if you have a quick question about something, you want to give me a call or you want to email me and say, Win, is this clause valid? I'm really concerned about it. It's just a one-liner, can we talk about that for a minute? I'd be more than happy to do that. That's what I'm here for. And hopefully, all right, Jim, I think you said that you would send out my email and number so that they could do that if need be.
Yes. The website is going to have a dedicated page for the Connecticut Law Seminar. We're going to keep that page up. It will have Attorney Win Smith's information on there. Someone asked a question about the credit code. You don't need that credit code because you're watching this live. The credit code is if you watch it after. But yes, all the information of Attorney Smith will be on the website, and please feel free to contact him anytime. It's a great resource. I want to thank you for your time tonight. This was really, really informative.
Thank you, Wayne.
I appreciate all of you taking the time, and I appreciate all the questions, and I'm sure we'll have more.
Thank you.
all.
Thank you.
Thank you. Have a good evening.
Have a good night.